Unit 7, Real Estate Brokerage and the Law of Agency. Learning Objectives. When you have completed this unit, you will be able to accomplish the following. Discuss the historical relationship of MLSs in co-brokered transactions, particularly as it affected subagency relationships. Define the common law of agency. Define terms associated with agency and non-agency relationships, such as principal, client, and customer. Explain the duties and liabilities of agents to their principals and third parties, particularly regarding disclosure practices and consequences for failure to act appropriately. Material facts that must be disclosed to both clients and customers. Prohibited acts such as omission and misrepresentation, as well as appropriate behavior regarding stigmatized properties and sex offenders, and consequences for breach of duties. Describe the responsibilities of principals to their agents and to third parties, and the consequences for failure to act appropriately. Classify agency relationships as universal, general, or special agency. Explain how brokerage relationships are created with the firm and with co-brokers, established and terminated. Explain various types of agency relationships and characteristics of each, as well as contrast the differences between client-level and customer-level responsibilities of brokers. Describe agency disclosure requirements in North Carolina, how, when, and to whom proper agency disclosures must be made. In particular, explain the proper handling of dual agency disclosure. Describe the scope of responsibility of the broker in charge to licensees within the firm, particularly from the perspective of the IRS. Key terms: agency, agent, apparent authority, as is, broker, brokerage, broker in charge, caveat emptor, client, co-brokered transaction, commingling, commission, common law of agency, cooperating broker, customer, designated dual agency, employee, express agreement, express authority, facilitator, fiduciary, first substantial contact, fraud, general agent, implied agreement, implied authority, independent contractor, in-house sale, material fact, multiple listing service, negligent misrepresentation, negligent omission, non-agency, old car, oral buyer agency, principal, provisional broker, huffing, ratification, self-dealing, special agent, stigmatized property, subagent, tort, transaction broker, undisclosed dual agency, universal agent, willful misrepresentation, willful omission, working with real estate agents. Learning objective: discuss the historical relationship of MLSs in co-brokered transactions, particularly as it affected subagency relationships. Introduction to brokerage and agency. The nature of real estate brokerage services, particularly those provided in residential sales transactions, has changed significantly over the years. Through the 1950s, real estate brokerage firms were primarily one-office, minimally staffed, family-run operations. The broker listed the owner's property for sale and found a buyer without assistance from other companies. Then the sale was negotiated and closed. It was relatively clear that the broker represented the seller's interests. In the 1960s, however, the ways buyers and sellers were brought together in a transaction began to change. Brokers started to share information about properties they had listed, which resulted in two brokers, firms cooperating with one another to sell a property. Brokers formalized this exchange of information by participating in multiple listing services. By increasing exposure to potential buyers, the MLS expedited sales and became a widely used industry service. Unfortunately, confusion can quickly arise over whom the broker represents in these co-brokered transactions where two competing firms cooperated to bring about a sale. For example, ABC Realty would have the listing and represent the seller, but XYZ Realty would bring the purchaser to the transaction. With two different brokerage firms involved in a sale, consumers could easily assume that there was a clear division of responsibility. Consumers may think that the broker who had the property listed for sale represents the seller. The broker who found the buyer represents the buyer. However, this may not be the case. Up until the mid-1990s, it was commonplace in these shared transactions that both brokerage firms and their brokers or salespersons represented the seller as agents and owed all loyalty to the seller and owed no duties other than honesty and fairness to the buyer. It was not only the public that was confused by this complex relationship. Brokers were confused as well. Often brokers who worked with buyers felt a closer kinship with their buyers, but had to act in their legal capacities as a representative of the seller. These brokers were subagents of the seller and the seller's listing firm. Sometimes this subagency relationship was established by local MLSs, which provided for a unilateral subagency, a relationship created when a seller listed property with a listing broker or firm. The listing broker submitted the listing to the MLS so the listing could be shared with other MLS members. These MLS members immediately became subagents of the seller. The seller became their client or principal. This common traditional view of agency began to erode when a lawsuit was filed in Minnesota that made buyers become aware and concerned about having their own representation. Seller subagency example. The buyer is unrepresented. Both ABC Realty and XYZ Realty represent the seller. XYZ Realty and its agent represent the seller and are seller subagents. The Edina lawsuit. In 1991, Jamie Bokuski, a consumer who was looking for a home in a suburb of Minneapolis, Minnesota, called Minnetonka, worked with an Edina Realty real estate licensee to purchase a home listed for sale with another Edina Realty agent. When she asked the broker with whom she was working if the home she was interested in purchasing had a sprinkler system, she was told yes. She purchased the home without having an independent inspection performed. As it turns out, Jamie's home had no sprinkler system. She turned to an attorney who initially advised her to avoid litigation since the costs of a lawsuit would far exceed those of installing a sprinkler system at her expense. But Jamie continued to press her point. She was sure that the broker she had worked with had her best interests at heart and should have negotiated on her behalf and advised her to obtain inspections. Jamie's attorney advised her that in fact all agents work for the seller, not for buyers. Since Jamie's broker was working for the seller but had given the impression that the broker was working for Jamie, Jamie's attorney reasoned that Jamie was the victim of undisclosed dual agency, a relationship that must be consented to by both parties. A class action lawsuit ensued. 20,000 other Edina Realty consumers also claimed that they had been victims of dual agency and filed a $250 million suit against the brokerage firm. Those suing asked the court to refund the estimated sales commissions Edina Realty earned on an average $6,000 in-house transaction a year over the 6 years covered by the litigation. Edina Realty was one of the largest real estate brokerage firms in the country at the time of the litigation, so the lawsuit gained a significant amount of public attention in the media over the ensuing months. The initial lawsuit snowballed into 3, including a suit brought by the United States Department of Justice charging Edina Realty under the Racketeer Influenced and Corrupt Organizations Act, commonly referred to as the RICO Act. RICO is a United States federal law that provides for extended criminal penalties and a civil cause of action for acts performed as part of an ongoing criminal organization. The central issue for the courts to consider became how much explanation do real estate agents owe customers about their legal relationship. In February 1995, judges approved settlements worth a combined $19.9 million, ending 3 lawsuits. Edina never admitted any wrongdoing and maintained that it acted lawfully at all times. Such misunderstandings ultimately led buyers to question exactly how their interests were being protected. This helped spur a growing trend in which buyer consumers began to demand that their rights be protected so that they could make informed decisions. State legislatures also acted to require that real estate licensees more candidly disclose various agency relationships to consumers. Today's consumers are much more likely to receive information about agency relationships early in their dealings with brokers. They are also likely to have much more choice in whether they are going to be represented or not. In many states, lawmakers have departed from the common law doctrine of caveat emptor, let the buyer beware, toward greater consumer protection. Buyers seek not only accurate, factual information, but also advice, particularly as real estate transactions have become much more complex. Buyers view the real estate broker as the expert on whom they can rely to guide them. Today, most buyers seek and obtain representation. Though North Carolina is still considered to be a caveat emptor state, while buyers should beware, buyers can trust real estate professionals, even those who represent buyers, to be honest and fair in their dealings. In the past, putting a listing into a local multiple listing service created a sub-agency relationship between cooperating brokers. True, the Edina lawsuit had no impact on the traditional view of agency. False. Learning objective. Define the common law of agency. A law of agency. The concept of agency, namely, a principal who authorizes someone else, known as an agent, to conduct certain business on behalf of the principal and thereby bind the principal, dates back to the early days of England. The resulting law, which evolved over time, is known as the common law of agency. The basic framework of the law that governs the legal responsibilities of the broker to the people the broker represents has not changed. However, its application has. The law of agency is a common law concept. It is being widely replaced or modified by state statute in many jurisdictions, but not in North Carolina. However, in 1995, the Edina case prompted the North Carolina Real Estate Commission to revise its agency rule to require licensees to provide specific agency disclosures in writing to buyers and sellers at first substantial contact in an effort to inform and protect the public, as well as to help North Carolina licensees avoid the type of liability Edina Realty incurred for practicing undisclosed dual agency. The Edina case also motivated brokers to reevaluate their services. They choose whether they will represent the seller, the buyer, or both in the sale or rental of property. They also must decide how they will cooperate with other brokers in a transaction. Since the Edina case, the brokerage business has undergone many changes as brokers focus on ways to enhance their services to buyers and sellers. The North Carolina Real Estate Commission strongly encourages the broker in charge of a real estate firm to have a written office policy as to the type of agency the firm will practice. The firm is technically the agent in a transaction. The company policy should cover whether the firm will practice seller single agency only, buyer single agency only, or dual and designated agency. Whichever form of representation the firm adopts, the written policy should clearly state how that type of agency representation will be exercised. The written policy also should explain how the firm will enter into cooperative relationships among other firms, how it will arrange commission splits, and how it will implement disclosure requirements. The common law of agency refers to laws from judgments and decrees of courts as opposed to laws created by a legislature. True. Learning objective. Define terms associated with agency and non-agency relationships, such as principal, client, and customer. General agency definitions. The job of being a real estate broker is commonly referred to as a real estate agent. Legally, however, the term agent refers to a strictly defined legal relationship. In the real estate industry, it is the relationship a licensee has with buyers and sellers. In the law of agency, the body of law that governs these relationships, the following terms have specific definitions. Agency, the fiduciary relationship between the principal, client, and the agent. Agent, the individual who is authorized and consents to represent the interests of another person. In the real estate industry, principals are hiring an entire company and all the company's affiliated brokers to represent them. Even though the firm is the agent, the broker in charge would be personally accountable for agency law compliance. Subagency, the fiduciary relationship between the subagent and the principal. Subagent, one who is employed by a person already acting as an agent. Simply stated, a subagent is an agent of an agent. Principal or client, the person who hires and delegates to the agent through a brokerage contract the responsibility of representing that person's best interests. In the real estate business, the principal, client can be the buyer, seller, landlord, or tenant. Customer, the third party for whom some level of service is provided by an agent of another party, but who is not represented by the agent. Fiduciary, a relationship in which the agent is placed in the position of trust and confidence to the principal. Facilitator, transaction broker, the real estate licensee who assists buyers and sellers in reaching an agreement in a real estate transaction without representing interests of either party. A licensee treats both parties equally as customers. This non-agency relationship is not allowed in North Carolina. There is a distinction between the level of services that agents provide to clients and the level they provide to customers. The client is the principal to whom the agent gives advice and counsel. The agent is entrusted with certain confidential information and has fiduciary responsibilities to the principal. In contrast, the customer is entitled to factual information and fair and honest dealings as a consumer, but does not receive advice and counsel or confidential information about the principal. The agent works for the principal and with the customer. Essentially, the agent is an advocate for the principal, but not for the customer. The relationship between the principal and agent must be consensual. The principal delegates authority. The agent consents to act. The parties must mutually agree to form the relationship. An agent may be authorized by the principal to use the assistance of others, called subagents of the principal. The term customer is synonymous with the terms principal and client. False. A real estate broker who does not represent either party in a transaction and treats both as customers is called a subagent. False. Learning objective. Explain the duties and liabilities of agents to their principals and third parties, particularly regarding disclosure practices and consequences for failure to act appropriately, material facts that must be disclosed to both clients and customers, prohibited acts such as omission and misrepresentation, as well as appropriate behavior regarding stigmatized properties and sex offenders, and consequences for breach of duties. Agents' responsibilities to principal. As mentioned earlier, an agency relationship is a fiduciary relationship, one of trust and confidence between the broker and the principal. In North Carolina, the general law of agency, along with contract law, North Carolina real estate license law, North Carolina real estate commission rules, and other state and federal laws determine the scope of the agent's fiduciary relationship. In a fiduciary relationship, the broker, by law, owes the principal specific duties, the duties of obedience, loyalty, disclosure of information, confidentiality, accounting, and reasonable skill, care, and diligence, easily remembered by the acronym OLDCAR. Note that such duties are not simply moral or ethical obligations. They are the law of agency. These duties are owed to a principal whether the principal likes the agent or the agent likes the principal. Agent's responsibilities to principal. Obedience. The fiduciary relationship obligates the broker to act in good faith at all times, obeying the principal's instructions in accordance with the contract. That obedience is not absolute, however. The broker may not obey any instructions that are unlawful or unethical. For example, the broker may not follow instructions to make the property unavailable to members of a minority group or to conceal a defect in the property, because illegal acts do not serve the principal's best interest. Obeying such instructions violates the broker's duty of loyalty, not to mention other laws making the conduct illegal. On the other hand, a broker who exceeds the authority assigned in the contract is liable for any losses that the principal suffers as a result. Loyalty. The broker firm owes the principal the utmost loyalty. That means placing the principal's interests above those of all others, including the broker's own. The agent must be particularly sensitive to any possible conflicts of interest. Confidentiality about the principal's personal affairs is a key element of loyalty. An agent may not, for example, disclose the principal's financial condition. When the principal is the seller, the agent may not reveal such things as the principal's willingness to accept less than the listing price or any anxiousness to sell unless the principal has authorized the disclosure. If the principal is the buyer, the agent may not disclose, for instance, that the buyer will pay more than the offered price if necessary, or that the buyer is under a tight moving schedule or any other fact that might harm the principal's bargaining position. Real estate transactions are ideally arm's-length transactions where all parties are dealing from equal footing without bias. Because the agent may not act out of self-interest, the negotiation of a sales contract must be conducted without regard to how much the agent will earn in commission. All states forbid brokers to buy property listed with them for their own use or in which they have a personal interest without first disclosing that interest and receiving the principal's consent. An agent must disclose to a client any personal or business relationship the agent may have with another party to the transaction, even if it is a former relationship, to avoid claims of self-dealing. NCREC rules do not allow brokers to represent buyers when brokers are selling property in which they have an ownership interest. Likewise, brokers cannot represent sellers when the brokers are acting as buyers. These actions would create conflicts of interest. There is nothing that stops brokers from buying or selling properties, but they are prohibited from representing the other side. However, brokers in these situations should consult with their brokers in charge and arrange for buyers or seller to get appropriate representation in these transactions, if desired. Note that commercial brokers have some latitude in these rules. As long as their ownership stake in listed properties is minimal, they may be permitted to represent buyers. Disclosure of information. Another very important duty of an agent to her principal is the duty of disclosure of information. It is the firm broker's duty to keep the principal fully informed at all times of all facts or information the broker obtains that could affect the principal's decision in the transaction. A broker who fails to disclose such information may be held liable for any damages that result. A broker must also disclose any personal benefit from the transaction, because making a secret profit out of a transaction is prohibited. The real estate agent also may be liable for facts he or she should have known and revealed to the principal, but did not. This duty of discovery includes facts favorable or unfavorable to the principal's position, even if the disclosure of those facts would end the transaction. Examples of facts an agent for the seller has a duty to disclose to the seller include all offers, the identity of the prospective purchasers, including the agent's relationship, if any, to them, the ability of the purchaser to complete the sale or offer a higher price, any relationship the broker has with the buyer, and the buyer's intention to resell the property for a profit. An agent for the buyer must disclose deficiencies of a property as well as factors that may adversely affect a property's value or desirability. The agent should disclose information that could affect the buyer's ability to negotiate the lowest purchase price, such as how long a property has been listed or why the seller is selling, if known by the agent. North Carolina requires that sellers of most residential properties give the buyer a completed mandatory residential property disclosure statement. While the real estate agent cannot fill out the form, the agent is required to inform the seller of the agent's responsibilities in regard to the property disclosure. Property disclosure is discussed in more detail in Unit 8. Confidentiality. Confidentiality is a key element of fiduciary duties. An agent shall not disclose the principal's financial condition, motivation, or acceptable contract terms without the client's permission. If the principal is the seller, the agent may not reveal such things as willingness to accept less than the listing price or urgency to sell, unless the principal has authorized the disclosure. If the principal is the buyer, the agent shall not disclose that the buyer is willing to pay a higher price, is under a tight moving schedule, or other facts that might affect the principal's bargaining position. Under the laws of most states, the broker must disclose material facts about the condition of the property even if the seller chooses not to disclose such facts, and even if the seller instructs the broker not to disclose such facts. Some states, however, permit a seller disclaimer, essentially a statement that the property is sold as its physical condition with no promises regarding its quality or condition. Note, however, that even with this disclaimer, most sellers are still required to disclose known problems with the property if they affect the health and well-being of the occupants. In North Carolina, a broker's disclosure responsibilities are not affected by his status under real estate license law. It is important to remember that anything a real estate agent learns about a client must remain confidential. In most states, confidentiality terminates upon completion, expiration, or termination of the agency relationship. Accounting. A broker must be able to account for all funds received from, or on behalf of, the principal. It is illegal for the broker to commingle such monies with personal funds. Commingling is a term used to describe when trust funds in the firm, broker's personal, business funds are placed in the same account. All states have laws that require accounting for trust funds and the maintenance of transaction files and records. North Carolina real estate license laws require that brokers give accurate copies of all documents to all parties affected by them and keep copies of such documents on file for 3 years. In addition, the license laws generally require that the broker deposit immediately all trust funds entrusted to the broker in a trust account. Example: a broker has accepted an earnest money deposit in connection with an offer to purchase, and deposits that money into his business account. A broker receives an earned commission check from another firm and deposits that check into the trust account. Both are examples of commingling, a mixing of trust funds with non-trust funds. Licensing law in North Carolina prohibits commingling. Reasonable skill and care. The broker must exercise a reasonable degree of skill, care, and diligence while transacting the business entrusted by the principal. The principal is entitled to expect the agent's skill and expertise in real estate matters to be superior to that of the average person. The most fundamental way in which the broker meets this standard is to use the broker's skill and knowledge on the principal's behalf. Whether acting as a buyer's agent or as a seller's agent, the broker has an affirmative duty to try to discover and disclose to the principal all facts that are pertinent to the principal's decision-making process in the transaction. If the broker represents the seller, the broker's duties include helping the seller arrive at an appropriate and realistic listing price, discovering and disclosing facts that affect the seller, and properly presenting the contracts that the seller signs. Skill, care, and diligence also means making reasonable efforts to market the property, such as advertising and holding open houses, as well as helping the seller evaluate the terms and conditions of all offers to purchase. A broker who represents the buyer will be expected to help the buyer locate suitable property and evaluate property values, neighborhood and property conditions, and financing alternatives, as well as to prepare offers and counteroffers with the buyer's best interest in mind. A broker who does not make a reasonable effort to properly represent the interests of the principal could be found negligent. The firm broker is liable to the principal for any loss resulting from negligence or carelessness. Agents' responsibilities to third parties. Even though an agent's primary responsibility is to the principal, the agent also has duties to third parties, often termed customers or prospects. The duties of an agent to a third party come from three sources: North Carolina license law and case law, general duty to treat any party honestly and fairly, and the North Carolina license law and commission rules. These duties include being honest and fair and complying with North Carolina real estate license law and NCREC rules, including disclosure of material facts relating to a property or transaction about which the agent has knowledge or should reasonably have acquired knowledge. Duties to third parties. When working with a buyer, a broker must exercise extreme caution and have knowledge of the laws and ethical considerations that affect this relationship. For example, brokers must be careful about the statements they or their brokers make about a parcel of real estate. General statements of opinion are permissible as long as they are offered as opinions without any intent to deceive. Statements of fact, however, must be accurate. Opinion statements that exaggerate a property's benefits are called puffing. Although puffing is legal and a common practice, it must not constitute a misrepresentation of the property. Brokers must ensure that none of their statements can be interpreted as involving fraud. Fraud is the intentional misrepresentation of a material fact in such a way as to harm or take advantage of another person. In addition to false statements about a property, the concept of fraud covers intentional concealment or non-disclosure of important facts. If a contract to purchase real estate is obtained as a result of fraudulent misstatements made by a seller's agent, the contract is voidable and may be disaffirmed or renounced by the purchaser. In such a case, the client loses a contract and the broker will lose a commission. If either party suffers loss because of a broker's misrepresentations, the broker can be held liable for damages. If the broker's misstatements are based on the owner's own inaccurate statements to the broker, however, and the broker had no independent duty to investigate their accuracy, the broker may be entitled to a commission even if the buyer rescinds the sales contract. Material facts. Brokers must also be careful not to make any misrepresentations or omissions where material facts are concerned. As noted previously, the common law of agency requires an agent to disclose to the principal any facts that might affect the principal's decision in a transaction. To determine an agent's duty to disclose material facts to a third party, one must look to the North Carolina real estate license law, which requires disclosure of material facts to all parties to the transaction regardless of whom the broker represents in the transaction. Per the North Carolina Real Estate Manual, the NCREC has historically interpreted material facts to be disclosed to any party under the real estate license law to include at least facts about the property itself, Facts relating directly to the property. Facts relating directly to the ability of the agent's principal to complete the transaction. And facts known to be of specific importance to a party. Some issues have been declared to be material facts by the North Carolina Real Estate Commission. For example, if a residence has ever been clad in an exterior insulating and finishing system commonly called EIFS, or synthetic stucco, that will remain a material fact for that property forever. Also, if a residence has ever had leaking polybutylene pipes, this must be disclosed even if the pipes were repaired or fully replaced. Finally, if a property was the site of a meth lab, this also must be disclosed. Agents have an affirmative duty to discover and disclose material facts to all transactional parties, not just the broker's clients. Examples of transactional parties include buyers and sellers, landlords and tenants, and even lenders. This obligation suggests that licensees must make appropriate disclosures even if consumers do not ask direct questions. As an illustration, when a broker notices something amiss, such as water stains on a ceiling, the broker must take the appropriate steps to determine if the water stains suggest an active leak. As another example, a buyer customer may not know about planned highway construction near a property she is interested in. Even though she makes no inquiry about highway construction, a broker must offer this information to the consumer. The duty to disclose material facts to a third party applies to a seller's agent working with a buyer, or buyer's agent, as well as a buyer's agent working with a seller or seller's agent. Generally, agents have a duty to treat any party honestly and fairly and to avoid conduct that constitutes improper, fraudulent, or dishonest dealing. Prohibited conduct. North Carolina real estate license law specifically prohibits the following types of acts in the broker's relationship with any party to the transaction. Willful misrepresentation, intentionally misinforming any party involved in a transaction about a material fact. Negligent misrepresentation, unintentionally misinforming any party involved in a transaction about a material fact. Willful omission, intentionally failing to disclose a material fact to any party involved in a transaction. Negligent omission, unintentionally failing to disclose a material fact to any party involved in a transaction. Willful misrepresentation. Willful misrepresentation takes place when brokers who have actual knowledge of a material fact deliberately misinform a buyer, seller, tenant, or landlord concerning such fact. Willful misrepresentation also takes place when a broker who does not have actual knowledge of a matter material to the transaction intentionally provides information concerning such matter to a buyer, seller, tenant, or landlord without regard for the truthfulness of the information. This is an act that is intentional on the part of the broker. A broker could also be involved in indirect misrepresentation, which occurs when an agent misrepresents a material fact to a subagent who in turn passes it on to a third party. If a material fact is misrepresented, courts could provide relief to the injured party in the form of damages or rescission of the contract. A broker guilty of misrepresentation could also face disciplinary action by the NCREC. Example: a broker tells a buyer the cost of utilities is very reasonable without verification from the owner. If the costs are very high, the broker could be guilty of willful misrepresentation. A broker tells a buyer the foundation of a house is sound and has been properly built, when the broker knows the foundation is substandard and improperly constructed. A builder explains to an agent that the poor exterior wall insulation resulted from the developer's overall goal of containing cost. When this agent's buyer-client asks about the insulation, the agent replies that the builder was highly reputable and he was certain the insulation met the necessary standards. A buyer signs a buyer agency agreement with an agent. The buyer wants to purchase property with low taxes. The agent informs the buyer that a particular property has annual taxes of $600, when in fact the agent knows the new assessed value will increase taxes to $1,200. Negligent misrepresentation. Negligent misrepresentation takes place when brokers unintentionally misinform a buyer, seller, tenant, or landlord concerning a material fact because they do not have actual knowledge of the fact, because they have incorrect information, or because of a mistake by the agent. If the broker should reasonably have known the truth of the matter that was misrepresented, then the broker may be guilty of negligent misrepresentation even though the broker was acting in good faith. The fact that the broker was ignorant about the issue is no excuse. If a buyer relies on the agent's statement, the agent is liable for any damages that may result. If a buyer's agent relies on incorrect information provided by a listing agent through the MLS property data, even with disclaimers, the buyer's agent may be held liable if the agent should reasonably have known the information was incorrect. Example: a listing agent relies on a recent appraiser's report that a house has 2,500 square feet of heated living floor space and enters that information into the MLS property data. However, the house actually has 2,000 square feet. Although the residential square footage guidelines written by the NCREC allows a broker to reasonably rely on a recent report from a qualified appraiser, a prudent and knowledgeable broker in this case should have recognized a 500 square foot error. If the agent unreasonably relied on the appraiser's report and informed the buyer the house has 2,500 square feet, she has made a negligent misrepresentation. A buyer's agent also should recommend that a buyer measure a property if square footage is important to the buyer. An agent tells a buyer client that the home being shown has leveler blinds throughout, without actually checking the brand name. The blinds are actually cheap, imported imitations of leveler blinds. Willful omission. Willful omission takes place when brokers have actual knowledge of a material fact and a duty to disclose such fact to a buyer, seller, tenant, or landlord, but deliberately fail to disclose such fact. Example: a broker knows that a highway relocation is pending that would adversely affect value and use of a property a buyer wants to purchase, but does not reveal this to the buyer. A broker lists a property in midwinter knowing that the air conditioning system does not operate properly, but does not reveal that fact to a prospective buyer. Negligent omission. Negligent omission takes place when brokers do not have actual knowledge of a material fact, but should reasonably have known of such fact. If they fail to disclose this fact to a buyer, seller, tenant, or landlord, they may be guilty of negligent omission, even though they acted in good faith in the transaction. Agents have an obligation to discover and disclose material facts about the property that any prudent agent would reasonably have discovered during the transaction. A listing agent would be held more accountable than would a buyer's agent in discovery and disclosure of defects in the property because of the listing agent's direct fiduciary relationship with the seller, and the fact that the listing agent inspected the property and should be more familiar with the property than the selling agent. Example: a broker has listed a property in a neighborhood where a vacant lot is being considered by the city for installation of a garbage recycling system. The plan has been well publicized in the news media, which also has given much publicity to the fact that the neighbors have filed legal action against the city. The agent does not reveal this information to a buyer, and when questioned, states that he was not aware of these plans. Frequently, the buyer or the buyer's mortgage lender will request inspections or tests to determine the presence or level of environmental risks. If environmental risk questions arise in a transaction, brokers should recommend that their customer obtain advice from state and local authorities responsible for environmental regulation or other appropriate experts. Whenever toxic waste dumping, contaminated soil or water, nearby chemical or nuclear facilities, or health hazards such as radon, asbestos, and lead paint may be present. In practice, NCREC has published other examples of these prohibited acts in the license law and rule comments section of North Carolina Real Estate License Law and Commission rules, to which the student is referred. Students should be thoroughly familiar with these topics. Stigmatized properties. Over the years, brokers have encountered what are called stigmatized properties, those properties branded by society as undesirable because of events that occurred there. Some properties are typically marked by a criminal event, a homicide, suicide, or other violence, illegal drug or gang-related activity, or other events that render the property socially unmarketable in the community's view. Another psychologically impacted property would be a purported haunted house, which is not a material fact. Under current North Carolina law, the death, even the violent death, or serious illness of a previous owner or resident of a residential property is not a material fact. Therefore, it need not be voluntarily disclosed to a prospective buyer or tenant by the listing agent. If the prospective buyer specifically asks the listing agent about the death or illness, the agent can refuse to answer. Any answer the agent chooses to give, however, must be truthful. The one exception to this rule is if the death or illness is AIDS-related. Because persons with AIDS are considered legally handicapped under fair housing laws, an agent cannot disclose this condition, even if asked. Instead, the agent should tell the person who asked the question that the agent is prohibited by law from answering the question. Sex offender disclosure. The previously mentioned general statutes also provide that the fact that a registered sex offender resides in or near a property for sale or lease is not a material fact requiring disclosure by brokers. The real estate broker's agency status in the transaction will have no effect on the requirement to disclose either the presence of the sex offender in the area or the existence of the state sex offender registry. It does not matter if the broker is a seller's agent, a landlord's agent, a buyer's agent, a tenant's agent, or a dual agent. If a broker chooses to voluntarily disclose the presence of the registered sex offender, or to advise a prospective buyer or tenant to visit the sex offender registry, it will not be a violation of the real estate license law. Providing false or misleading information when asked about the presence of sex offenders in a given area will be construed by NCREC as a violation of the real estate license law. Additional duties. In addition to the duties outlined, license law and rules also require that licensees have a duty to avoid making any false promises to the principal, avoid any undisclosed conflict of interest, properly account for funds held in trust for the principal, act competently in the performance of services required by the agency relationship, avoid improper conduct and to be honest in all dealings with the principal, deliver all offers and contracts to the principal, and disclose any commission, referral fees, kickbacks, and similar payments from third parties. In practice, because real estate brokers have, under the law, enormous exposure to liability, some brokers purchase errors and omissions insurance policies for their firms. Similar to malpractice insurance in the medical field, such policies generally cover liability for errors, mistakes, and negligence in the usual listing and selling activities of a real estate office. Individual agents, likewise, should be insured. Note that no insurance will protect a broker from litigation arising from criminal acts such as fraud. Also, insurance companies normally exclude coverage for violation of civil rights laws. Errors and omission insurance also will not relieve a licensed agent from disciplinary action by the NCREC. Liabilities and consequences of breach of duty. Any agent who breaches an agent's duties to either the principal or a third party must bear the consequences of that breach. These consequences may include any of the following: disciplinary action by NCREC. Any violation of a duty owed to the principal or third parties is grounds for disciplinary action by NCREC. If the commission finds that the agent did in fact violate the license law, that agent's license may be revoked or suspended. A civil action in court brought by the injured party. If the breach of duty harms either the principal or a third party, the agent may be sued and found liable for the damages caused by the breach. Note that if the agent's improper behavior is deemed to be within the scope of the agent's duties, the agent's principal also may be held liable for the damages caused by the agent. The principal can in turn sue the agent for reimbursement for those damages. Criminal prosecution brought by the district attorney, a violation of a provision of the real estate license law, is also a misdemeanor. If the agent's breach of duty also is a criminal act, such as fraud or embezzlement, the district attorney may bring a criminal action against the agent. A broker owes a third party honesty and fairness, as well as other fiduciary responsibilities. False. Willful misrepresentation is the act of intentionally misinforming any party involved in a transaction about a material fact. True. Learning objective. Describe the responsibilities of principals to their agents and to third parties, and the consequences for failure to act appropriately. Duties and liabilities of principals. Duties to agent. A fiduciary relationship is, in a sense, a two-way street. While the agent has significant duties to the principal client, the principal also has the following responsibilities to the agent. To act in good faith, for example, if the seller client refuses to let the agent show the property, this is a breach of good faith. To pay the agent the agreed on compensation when the agent finds a ready, willing, and able buyer once the agent brings the seller a buyer who is ready, willing, and able to purchase the property on the seller's terms. The agent has earned a commission whether or not the seller decides to sell the home. Similarly, the principal client is a buyer. The buyer is obligated to make sure that his or her agent is compensated for the agent's efforts to find the appropriate property. Duties to third parties. Historically, real estate transactions were governed by the doctrine of caveat emptor, or let the buyer beware. The principal was liable to a buyer only if the principal willfully misrepresented the property. It was up to the buyer to thoroughly examine and research the property, and the buyer was, for all intents and purposes, expected to purchase the property as is. Property owners had no affirmative duty to reveal defects about the property. This is still true in North Carolina. Sellers are always liable for fraudulent misrepresentations. Unfair or Deceptive Trade Practices Act. North Carolina's GS 75-1.1 Unfair or Deceptive Trade Practices Act also applies to real estate agents, including posting on the internet and social media. Agents who engage in the prohibited acts described previously may find themselves liable for treble damages and attorney's fees under certain circumstances. Liabilities and consequences of breach of duty. The principal who violates the principal's duties either to the agent or to a third party is liable for the damage caused. The principal may be subject to both a civil lawsuit and criminal prosecution. The principal also may be held liable and accountable for the agent's misconduct, referred to as a tort, which is a wrongful act by an agent while representing the principal and acting within the scope of the employment agreement that created the agency. The North Carolina Residential Property Disclosure Act. Duties regarding disclosure are also included in the North Carolina Residential Property Disclosure Act. This act and the duties included will be discussed in detail in Unit 8. A broker who violates any duties owed to a third party can be penalized by the North Carolina Real Estate Commission. True, a broker who chooses to voluntarily disclose the presence of registered sex offenders is not a violation of the real estate license law. True, learning objective. Classify agency relationships as universal, general, or special agency. Classification of agency relationships. An agent may be classified as a universal agent, general agent, or special agent, based on the nature of the agent's authority. A universal agent is a person who is empowered to do anything the principal could do personally. There are virtually no limits to the universal agent's authority to act on behalf of the principal. An unlimited power of attorney would be an example of universal agency. This type of agency is seldom practiced by a real estate broker in a typical real estate transaction. A general agent may represent the principal in a broad range of matters related to a particular business or activity. The general agent may, for example, bind the principal to any contracts within the scope of the agent's authority. A real estate broker typically does not have this scope of authority as an agent for a consumer in a real estate sales transaction. Brokers usually serve as general agents of their real estate brokerage firms. A more typical example of a general agent would be a property manager hired as a general agent for the landlord in the management of certain properties. A special agent is authorized to represent the principal in only one specific act or business transaction, and under limited, detailed instructions with no power to bind the principal. A real estate broker is usually a special agent. If hired by a seller, the broker's duty is limited to finding a ready, willing, and able buyer for the property. A special agent for a buyer has the limited responsibility of finding a property that fits the buyer's criteria. As a special agent, the broker cannot bind the principal to any contract. It is important to remember that a special agency relationship provides only limited authority. An unlimited power of attorney would be an example of special agency. False. As a special agent, a broker cannot bind the principal to any contract. True. Learning objective. Explain how brokerage relationships are created with the firm and with co-brokers, established and terminated. Brokerage defined. It is important to look more closely at the parties who provide the client and customer services in a real estate agency relationship. Brokerage is the business of bringing buyers and sellers together in the marketplace. Buyers and sellers in many fields of business employ the services of brokers to facilitate complex business transactions. In the real estate business in North Carolina, a broker is defined as a person who is licensed to list, lease, buy, exchange, auction, negotiate, or sell interest in real property for others and to charge a fee for services. The provisional broker works under direct supervision of the broker in charge. The principal who employs the firm may be a seller, a prospective buyer, an owner who wishes to lease out property, or a person seeking property to rent. The real estate firm or broker in charge acts as the agent of the principal, and the brokers employed by the firm act as the subagents of the principal. The principal usually compensates the firm with a commission, contingent on the firm successfully performing the service for which it was employed. That service generally involves negotiating a transaction with a prospective purchaser, seller, landlord, or tenant who is ready, willing, and able to complete the contract. However, the source of compensation does not necessarily dictate the agency relationship. In a typical real estate listing contract, the seller will authorize the firm to use brokers employed by the firm as well as other cooperating brokers, firms. Cooperating brokerages through agreement with the listing firm may act as subagents of the seller principal, and may in turn employ their own brokers. However, this form of subagency is increasingly rare in many parts of North Carolina. It is a much more prevalent trend that cooperating brokers in a co-brokered transaction represent the buyers and are their agents. The relationship of a broker to an employing broker firm is also an agency relationship. The individual broker is, therefore, the agent of his firm in addition to being the subagent of the principal client. Subagent, subagency within one firm. At one time, local associations of realtors required that co-brokers working with buyers had to be subagents of the listing firm. This is no longer the case. Realtor Board Association MLSs may not require that members make blanket offers of subagency to other members. Instead, MLS members offer cooperation with compensation to other members. Thus, other members of the MLS may find a buyer for listed property while working as a subagent of the listing agent, or as an agent of the buyer. The cooperating agent may then receive a portion of the listing commission when the sale closes or possibly seek compensation from the buyer, client. Listing brokers may offer differing compensation amounts to subagents than to buyer agents. Listing brokerage firms may do so based on the perceived liability of cooperating with other firms as subagents of their clients. Creation of agency. Brokers are employed for their expertise. However, providing services does not in itself create an agency relationship. No agency exists without mutual consent between the principal and the agent. The agent consents to undertake certain duties on behalf of the principal, subject to the principal's control. The principal authorizes the agent to perform these acts when dealing with others. Common law agency relationships can be created in the following ways. With a written listing contract where a seller employs an agent to produce a buyer for the property. The seller is the principal, the broker is the seller's agent. With a buyer agency contract where a prospective buyer hires a broker to locate properties for the buyer with buyer representation. The buyer is the principal, the broker is the buyer's agent. With a dual agency contract where the agent legally represents both parties, both seller and buyer are principals, broker is agent to both, but written informed consent from both parties is required. With a property management contract where the owner of rental properties engages the services of an agent to rent and manage the property, the owner is the principal, and the broker is the property manager, agent. With an in-house brokerage employment contract where a broker signs an employment agreement with a broker that defines the legal and agency relationship between them. The broker is the principal and the broker is the agent. With a tenant representation agreement where a tenant employs an agent find properties for the tenant is the principal, and the broker is the tenant's agent. By the conduct of the parties. Scope of authority. Under general agency law principles, an agency relationship can be created by either an oral or a written agency agreement between the principal and the agent. It also can be implied from conduct. To ensure that all parties have a clear understanding of the agency relationship, it is in everyone's best interest to create an agency relationship through an expression of agreement rather than through implication. Principal and agent should have an express agreement, such as those reviewed in Unit 8. An agent with such an agreement would be acting with express authority. Agency relationships also can be created by implied agreement when principal and agent, without formally agreeing to the agency, act as if one exists. An agent with such an understanding would be acting with implied authority. However, an implied contract will not be established simply on trade custom and practice. There must be sufficient evidence to show that the principal authorized the agent to perform acts under circumstances in which a reasonable principal would be expected to compensate the agent for the services. For example, the fact that a seller simply allows a broker to show the property is not sufficient to create an implied agency agreement. Implied agency agreements are illegal under North Carolina real estate license law, which requires all agency agreements be in writing. When someone claims to be an agent but there is no express agreement, the principal can establish an agency relationship by ratification. In other words, by performing any act that accepts the conduct of the agent as that of an agent. Compensation. Creation of an agency relationship must include promise of compensation to the agent by the principal. An agent owes his loyalty to the party who employs him. That party may or may not be the party who pays him. Because the source of an agent's compensation does not necessarily determine whether an agency relationship exists between two parties, an agent might not represent the party who pays the commission. In theory, an agency relationship can exist even if there is no fee involved. However, such situations are rare, especially in real estate transactions. Buyers and sellers can make any agreement with a firm, broker they choose about compensating the firm. Broker, regardless of which one is the agent's principal. For example, the seller could agree with the listing firm, broker, to pay a commission to the broker who is the buyer's agent. North Carolina real estate license law mandates that an agency agreement must be in writing in order for a broker to be entitled to compensation. All agency agreements should state how the agent is being compensated. Termination of agency. When an agent completes an assignment, the agency relationship ends, as does all responsibility to that former principal. An agency agreement may be terminated at any time for any of the following reasons: completion or fulfillment of the purpose for which the agency was created. The property went under contract and closed during the listing period. Expiration of the terms of the agency. The beginning date for the agency agreement is September 2022 and the expiration date is January 15, 2023. The property did not sell during the listing period. Therefore, the agency agreement expired. Mutual agreement to terminate the agency. A buyer had a written buyer-agency agreement with a firm with a beginning date of January 1, 2022 and expiration date of January 1, 2023. The buyer decided not to move to the area and asked the firm if they would mutually agree to cancel the agreement. The firm and the buyer mutually agreed to cancel the written buyer-agency agreement. Breach by one of the parties, such as abandonment by the agent or revocation by the principal. By operation of law, as in a bankruptcy of the principal. Destruction or condemnation of the property. If a seller signs an exclusive right to sell listing agreement with a firm to list a 1-acre lot that includes a 3,000 square foot house, and the house burns to the ground, the listing agreement would terminate. Death or incapacity of either party. Duty generally ends when agency ends, with the following exceptions. Express promise or implied obligation. For example, if an agent is still holding a client's money after the termination of the agency relationship, the agent still owes the client the duty to safeguard and account for the money. Pending transaction at termination date of agency agreement. For example, in a sales transaction when a buyer-agency contract expires after the buyer has entered into a contract. But before the transaction has closed, the broker will continue to owe agency duties to the buyer. Self-dealing. The broker seeks to deal on their behalf after the listing has expired. The courts have held that real estate brokers have a continuing duty of loyalty and good faith to the former principal to the extent that the brokers may not use their former position of confidence to profit or gain an unfair advantage over former clients. For example, a broker lists a property for sale at $300,000 and does not sell during the listing period. The broker finds a buyer willing to pay the full price the day the agency agreement is set to expire. After the listing expires, the broker offers to purchase the property from the seller for $250,000 and then turns around and sells to the buyer for $300,000. Duty of confidentiality may be expected to continue as long as the agent has no duty to disclose to a new client. Agency relationships can be created with a listing contract, property management contract, tenant representation agreement, and by conduct of the parties, among other examples. True, agency relationships can end by the fulfillment of the purpose for which the agency was created. True, learning objective. Explain various types of agency relationships and characteristics of each, as well as contrast the differences between client-level and customer-level responsibilities of brokers. Agency relationships. A variety of agency relationships may be created. The distinctions between them are not always clear. When consumers feel their individual interests have not been adequately protected, brokers may face legal and ethical problems. The broker in charge must decide the agency policies and procedures for the firm, determine who will be represented, disclose the agency alternatives to each party, and then act according to the agency relationship defined. In North Carolina, every agreement for brokerage services in real estate transactions must be in writing. Real estate agency relationships typically are created with a listing agreement, a property management agreement, a buyer agency or buyer representation agreement, or a tenant agency agreement. Listing agreements and buyer agency agreements will be discussed in detail in Unit 8. Type of agency relationship. Description of agency relationship. Exclusive seller agency. Seller is the client, buyer is the customer. Exclusive buyer agency. Buyer is the client, seller is the customer. Single agency. Either the buyer or the seller is the client, but not both in the same transaction. Dual agency. Both the buyer and the seller are the clients in the same transaction. Facilitation, transaction, brokerage. Neither the buyer nor the seller are clients, both are customers, not permitted in North Carolina. Exclusive seller agency. The exclusive seller agency brokerage firm was a common form of business prior to the Edina lawsuit discussed earlier. Most firms represented sellers. They limited their practice to listing and worked with buyers only to achieve the seller client's goals. Buyers were customers, but were sometimes treated in a way that confused them about the role of the real estate licensee assisting them. In addition to the possible confusion that can be caused by a firm that represents sellers only, consider the problem when those sellers, after closing on the sale of their properties, now want the same firm to assist them in locating new properties. The firm would have to treat their former seller clients as buyer customers. This turnabout in relationships, if understood by the consumer, would not encourage long-term trust and confidence. A firm that practices exclusive seller agency is essentially saying to the seller, as long as you are a seller, you are my client. But if we assist you when you become a buyer, we have to downgrade our relationship. Aware of illegal undisclosed dual agency through careless actions of brokers. Buyer agency. When a buyer contracts with a firm broker to locate property and represent the buyer's interests in the transaction, the buyer is the principal, the broker's client. The broker as agent is strictly accountable to the buyer. The seller is the third party or customer. In the past, it was simple. Brokers always represented sellers, and buyers were expected to look out for themselves. With the widespread use of MLSs and subagency, a buyer often had the mistaken impression that the subagent was the buyer's agent, although the reality was that both agent and subagent exclusively represented the seller's interest. Today, however, many residential brokers recognize the opportunities afforded by buyer representation. Some brokers have become specialists in the field of buyer brokerage, representing buyers exclusively. While there are advantages to establishing a practice that devotes itself to the buyer's needs, just like there are disadvantages in exclusive seller agency, there are potential problems with limiting a brokerage practice to buyer agency. For example, it is common for residential buyers to enjoy their homes for 7 to 10 years, but then wish to move to a new location. If brokers have been professional in their dealing with those buyers, these clients will contact their previous agents to now list those homes. But exclusive buyer brokerage firms will have to decline the opportunity since they do not take listings. Only buyers can be their clients. Sellers will be customers. For sellers to receive representation on the sale of their listed properties, they will have to hire a different firm. Buyer agency example. Real estate regulatory agencies across the country have developed rules and procedures to regulate such buyers, brokers, and local real estate associations have developed agency representation forms and other materials for them to use. The buyer agency agreement forms are discussed in Unit 8. Professional organizations offer assistance, certification, training, and networking opportunities for buyer's agents. A buyer's agent may receive a flat fee or a share of the listing commission or both, depending on the terms of the agency agreement. A buyer agency or tenant agency relationship is also established by express contract or agreement. Unlike agency agreements with a property owner, buyer agency may be oral initially, but must be reduced to writing before the presentation of an offer to any party to the transaction. It is recommended that an offer not be written before an agency agreement is in writing. If the agent seeks to restrict the buyer's right to work with other agents or independently, or to bind the client to the agent for any specified period, then the buyer agency agreement must be in writing from the formation of the restricted relationship. Single agency. In single agency, the agent represents only one party in any single transaction. The real estate agent must provide either fiduciary or statutory duties exclusively to one principal within the transaction. The customer is the party not represented by the agent. Single agency. Single agency brokerage is a practical alternative to representing only sellers or buyers. Firms which practice single agency are happy to represent buyers or sellers and treat them as clients regardless of their goals. Thus, a firm which is hired by seller can later maintain that client relationship when the seller becomes a buyer. Buyer brokers can be engaged to help the consumer locate the right properties and later take listings from those very same consumers, but maintain client-level relationships with them. For example, if a buyer has hired XYZ Realty and wants to see and make an offer on a property listed with ABC Realty, the buyer would have exclusive or single agency with XYZ Realty, and the seller would have exclusive or single agency with ABC Realty. The buyer would receive all fiduciary duties from XYZ Realty, and the seller would be a customer of XYZ Realty. And the seller would receive all fiduciary duties from ABC Realty, and the buyer would be a customer of ABC Realty. While a single agency broker may represent sellers or buyers, that broker will not represent both the buyer and the seller in the same transaction because that would require dual agency. Single agency avoids conflicts and results in client-based service and loyalty to only one principal. Subagency. A subagency is created when one broker firm, usually the seller's agent, appoints other brokers, firms to assist in performing client-based functions on the principal's behalf. These cooperating brokers, firms have the same fiduciary obligations to the seller principal as the listing broker, assisting in producing a ready, willing, and able buyer for the property. The listing broker and the seller now become potentially liable for the conduct of all of the cooperating brokers, firms and their affiliated brokers. Vicarious liability is a legal concept that might allow a consumer to successfully sue the seller or the listing firm for illegal or inept actions performed by the subagent firm or its brokers. It is also important to note that when a real estate broker firm becomes an agent under an agency agreement with a principal, all individual real estate brokers affiliated with the broker firm automatically become subagents of the principal unless there is a specific agreement to the contrary. Subagency. Note that the terms subagent and subagency usually refer to a firm's brokers, but they may refer to co-brokerage firms and their brokers. As discussed earlier, when a co-brokerage firm acts as a subagent of the seller, buyers are not represented by any of the licensees involved in the sale. If buyers are not properly educated about their relationship with the brokers in the transaction, they may become confused and think that they are clients rather than customers. The role of brokers in properly disclosing their agency relationships is particularly critical when they are not representing parties with whom they work on a regular basis. Dual agency. Many real estate transactions are co-brokered. That is, they involve two or more competing brokerage firms that cooperate by bringing the buyer and seller together. In the majority of co-brokered transactions, the firm with the listing represents the seller and the firm with the buyer represents the buyer's interests. Firms do reap financial rewards when the transaction is an in-house sale, that is, the listing agent and the selling agent are within the same firm. Thus, the firm keeps the entire commission and does not have to split it with outside brokerages. Large firms with many listings are likely to produce buyers through their marketing efforts and may keep control of the transaction rather than involving other firms. While an in-house sale does not have to involve dual agency, it is likely that it will be a dual agency situation. In a dual agency situation, the broker firm represents both the buyer and the seller in the same transaction. Dual agency requires that the agent be equally loyal to two separate principals at the same time. The challenge is to fulfill the fiduciary obligations to each principal without compromising fiduciary obligations to the other. Dual agency example. In a dual agency situation, the broker firm represents the buyer and the seller in the same transaction. Dual agency requires that the agent be equally loyal to both. Under the strict terms of the law of agency, dual agency seems to be a logical impossibility. How can one person serve two masters, especially when their interests are not only separate but may also be opposite? Because agency originates with the broker firm, dual agency arises when the broker firm is the agent of both parties in the same transaction. The firm brokers, as agents of the brokerage firm, have fiduciary responsibilities to the same principals as well. A real estate firm, broker representing one party in a transaction, shall not undertake to represent another party in the same transaction without the express approval of both parties. Example: a real estate broker is the agent for the owner of Roomy Manor, a large mansion. A prospective buyer comes into the real estate broker's office and asks for representation in a search for a modest home. After several weeks of activity, including 2 offers unsuccessfully negotiated by the broker, the prospective buyer spots the for sale sign in front of Roomy Manor and wants to make an offer and asks for his advice on a likely price range. The real estate broker is now in the difficult position of being a dual agent by representing the seller and the prospective buyer. Undisclosed dual agency. Undisclosed dual agency is not permitted. In order to act as a dual agent, a broker must first obtain written authorization from all parties at the appropriate time. A broker firm may not intend to create a dual agency situation. However, by a broker associates words and actions, it can occur unintentionally or inadvertently. Sometimes the cause is carelessness. Other times the subagent does not fully understand the fiduciary responsibilities. Some brokers lose sight of other responsibilities when they focus intensely on bringing buyers and sellers together. For example, a broker representing a seller might tell a buyer that the seller will accept less than the listing price, which is a breach of the duty of loyalty. Giving a buyer any specific advice on how much to offer can lead the buyer customer to believe that the broker is their agent or advocate. This would create an implied agency with the buyer and violate the duties of loyalty and confidentiality to the principal seller. Because neither party has been informed of the situation or given the opportunity to seek separate representation, the interests of both are jeopardized. This undisclosed dual agency violates license laws and the law of agency. It can result in rescission of the sales contract, forfeiture of the commission, or the filing of a suit for damages. Example: using the previous Roomy Manor example, the real estate broker must tell the prospective buyer that he represents the seller of the property, or he will be an illegal undisclosed dual agent. Knowing the buyer's comfortable financial situation and intense desire for the property, the broker might choose not to tell about the dual agency situation. If the broker told her that Roomy Manor's owner will accept nothing less than the full asking price, this will ensure that the broker receives the maximum possible commission, but it will also subject him to severe penalties for violating the state's license laws. Alternatively, the broker should disclose his relationship with the seller and work out a dual agency agreement with both parties in which he legally and impartially represents both parties' interests. A more common example of dual agency would be if the real estate brokerage firm employed 2 brokers. One is the listing agent for Roomy Manor, and the other is the buyer's agent. Because both brokers are associated with the same real estate brokerage, the broker in charge and his affiliated brokers will still be acting as dual agents and have to enter into a legal disclosed dual agency agreement with the parties. Dual agency is also created when the listing agent and buyer agent work for the same firm, but in different branch offices. Dual agency can be created, then, in a number of ways. One individual broker represents both the buyer and the seller in the same transaction. Two brokers working for roomy manner at the same office location. But one broker works with the seller and one broker works with the buyer. And two brokers working for roomy manor, but one works at the Markdale branch location and works with the seller, and the other works at the Sunnydate branch location and works with the buyer. All three situations are examples of dual agency. Perhaps, however, the situation that is most difficult for the firm to handle is the first one, where one agent represents both parties and potentially knows too much about both clients to act lawfully and ethically. Types of dual agency. Disclosed dual agency. Although the possibility of conflict of interest still exists, disclosure is intended to minimize the risk for the broker. The disclosure alerts the principals that they might have to assume greater responsibility for protecting their interests than they would if they had independent representation. Because the duties of disclosure and confidentiality are often limited by the express terms of the dual agency agreement, the effect of these limitations, as well as any other reduction in the services the broker may provide, they must be carefully explained to the parties in order to establish informed consent. Dual agency should be purposely created. In North Carolina, the key to lawful dual agency is that all parties must be informed and must consent to the broker representing both of them in the same transaction. In North Carolina, a firm that represents more than one party in the same real estate transaction is a dual agent, and must disclose its dual agency status to the parties. The written authority for dual agency must be obtained upon the formation of the relationship, except when an agent is working with a buyer or tenant under an oral agency agreement pursuant to A 104, in which event the express oral authority for dual agency must be reduced to writing not later than the time that one of the parties represented by the agent makes an offer to purchase, sell, rent, lease, or exchange real estate to another party. Though the possibility of conflict of interest still exists, the disclosure is intended to minimize the risk for the broker and ensure that both principals are aware of its effect on their respective interests. Written authorization to practice dual agency within a North Carolina transaction is typically obtained in the original agency agreement, which will be discussed further in Unit 8. Throughout any discussion of agency duties, it is important to remember that an agent's duties to the principal are greater than the agent's duties to the customer. However, a dual agent represents both parties equally. Therefore, the agent and subagents are generally restricted by the dual agency agreement from disclosing to either client the following types of information about the other party without that party's written permission: willingness to accept any terms of sale other than those offered, motivation for participating in the transaction, any confidential information unless disclosure is mandated by statute. Consequently, a dual agent is required by law to disclose all material facts about the property to both principals, but is absolved from disclosing confidential information about either principal by the terms of the dual agency agreement. The appropriate paragraphs of North Carolina Real Estate Commission Rule A 104 are quoted as follows. A real estate broker representing one party in a transaction shall not undertake to represent another party in the transaction without the written authority of each party. The written authority must be obtained upon the formation of the relationship, except when a buyer or tenant is represented by a broker without a written agreement in conformity with the requirements of paragraph of this rule. Under such circumstances, the written authority for dual agency must be reduced to writing not later than the time that one of the parties represented by the broker makes an offer to purchase, sell, rent, lease, or exchange real estate to another party. A firm that represents more than one party in the same real estate transaction as a dual agent, and, through the brokers associated with the firm, shall disclose its dual agency to the parties. When a firm represents both the buyer and seller in the same real estate transaction, the firm may, with the prior express approval of its buyer and seller clients, designate one or more individual brokers associated with the firm to represent only the interests of the seller, and one or more other individual brokers associated with the firm to represent only the interests of the buyer in the transaction. The authority for designated agency must be reduced to writing not later than the time that the parties are required to reduce their dual agency agreement to writing in accordance with paragraph of this rule. An individual broker shall not be so designated and shall not undertake to represent only the interests of one party if the broker has actually received confidential information concerning the other party in connection with the transaction. A broker in charge shall not act as a designated broker for a party in a real estate sales transaction, when a provisional broker under his or her supervision will act as a designated broker for another party with a competing interest. When a firm acting as a dual agent designates an individual broker to represent the seller, the broker so designated shall represent only the interest of the seller, and shall not, without the seller's permission, disclose to the buyer or a broker designated to represent the buyer that the seller may agree to a price, terms, or any conditions of sale other than those established by the seller. The seller's motivation for engaging in the transaction unless disclosure is otherwise required by statute or rule, and any information about the seller that the seller has identified as confidential unless disclosure of the information is otherwise required by statute or rule. When a firm acting as a dual agent designates an individual broker to represent the buyer, the broker so designated shall represent only the interest of the buyer, and shall not, without the buyer's permission, disclose to the seller or a broker designated to represent the seller that the buyer may agree to a price, terms, or any conditions of sale other than those established by the buyer. The buyer's motivation for engaging in the transaction unless disclosure is otherwise required by statute or rule, and any information about the buyer that the buyer has identified as confidential unless disclosure of the information is otherwise required by statute or rule. A broker designated to represent a buyer or seller in accordance with paragraph of this rule shall disclose the identity of all of the brokers so designated to both the buyer and the seller. The disclosure shall take place no later than the presentation of the first offer to purchase or sell. When an individual broker represents both the buyer and seller in the same real estate sales transaction pursuant to a written agreement authorizing dual agency, the parties may provide in the written agreement that the broker shall not disclose the following information about one party to the other without written permission from the party about whom the information pertains. That a party may agree to a price, terms, or any conditions of sale other than those offered. The motivation of the party for engaging in the transaction, unless disclosure is otherwise required by statute or rule, and any information about a party that the party has identified as confidential, unless disclosure is otherwise required by statute or rule. Designated dual agency. Designated dual agency example. Designated dual agency is used when one broker or firm who represents both parties in a transaction believes that the challenges of the client's best interests are too difficult. The broker or the BIC may wish to appoint one or more brokers of a firm to exclusively represent the seller as an agent, and appointing another broker of the same firm to exclusively represent the buyer as an agent. The firm continues to act as a dual agent. The individually designated brokers do not. Designated dual agency, sometimes called designated agency, might be used when one broker who represents both parties in a transaction believes that the challenges of the client's best interests are too difficult. The broker or the broker in charge may wish to appoint one or more brokers of a firm to exclusively represent the seller as an agent, and appointing another broker of the same firm to exclusively represent the buyer as an agent. However, designated agency must be done with prior express approval of both the seller and the buyer. The firm continues to act as a dual agent. The individually designated brokers do not. The major advantage of designated dual agency is that both of the firm's clients receive a fuller and direct representation from their respective designated agent. If a firm wants to practice the designated dual agency option, the BIC must establish a comprehensive written company policy on designated agency, and this policy must comply with North Carolina Real Estate Commission rules. Firms electing to practice designated dual agency must specify who within the firm is authorized to appoint designated agents. This person is normally the BIC. If a firm practices dual agency and designated dual agency, full written disclosure of this practice should be given to clients and customers at the earliest opportunity. When a firm enters into an agency contract with the seller, client, or buyer, client, the client must be given an opportunity to indicate in writing which agency relationship he or she is authorizing. The authority for designated agency must be reduced to writing not later than the time that the parties are required by NCREC rule to reduce their dual agency agreement to writing. The timing of obtaining written consent of dual agency and designated dual agency can be confusing. To determine whether or not a property can be shown to a buyer, consider these three examples provided by the NCREC in its 2009 to 2010 Broker in Charge Annual Review Course. Examples of oral versus written consent for dual agency. Situation number 1. The seller agreement does not authorize dual agency in the listing agreement. Consumer contacts listing company to see the property. The broker reviews the disclosure form and offers to show the property as a seller agent, cautioning the buyer that nothing the buyer reveals is confidential and the buyer should act as if he or she is talking directly to the owner, seller. If the buyer agrees, the broker provides written notice of seller agency and shows the property. Answer: dual agency has not been attempted in this situation. The company already has one principal who has not authorized its agent to function as a dual agent. The listing broker offers to work with the buyer as a seller agent, its only permitted avenue at present, and the buyer, having received the agency disclosure form and having been cautioned as to the lack of confidentiality by the listing agent, consents to the listing agent acting solely as a seller agent. Leasing agents may always work with prospective buyers, tenants as owner agents only, so long as the broker's agency status is disclosed and the buyer, tenant knowingly consents and does not insist on independent representation. Situation number 2. The seller agreement does not authorize dual agency in the listing agreement. A broker in the company is working with a buyer under an oral buyer agency agreement. The buyer now wants to see one or more of the company's listings. Answer: if the oral buyer agency agreement does not already authorize dual agency, the broker first must explain dual agency to the buyer and obtain the buyer's consent. Then, before the broker may show the property, the broker first must contact its other principal, the seller, explain dual agency, and obtain the seller's consent at least orally. If the seller refuses to consent, then the property may not be shown to the buyer client. Note: even though the listing agreement is already in writing and does not authorize dual agency, the seller's oral consent to dual agency as to that buyer is sufficient only because the buyer agency agreement is still oral. If after viewing the property, the buyer wishes to make an offer, the buyer agency agreement first must be reduced to writing and must contain authorization for dual or designated agency before any offer is presented. Further, the seller's written consent to dual designated agency, as least for this buyer, must be obtained before the offer may be presented. This may be done as an amendment to the listing agreement or as an addendum to the listing agreement, but it must be in writing before the offer is presented. Brokers are strongly advised to first obtain all necessary agency authorizations in writing before they prepare an offer. Otherwise, they may waste time preparing an offer they cannot present. Situation number 3. The seller agreement authorizes dual and designated agency in the listing agreement. Buyer agency agreement is in writing and does not authorize dual agency. Buyer wants to see the company's listing. Answer: in this situation, because both the listing agreement and the buyer agency agreement are already in writing, oral consent to dual agency will not be sufficient. The buyer client must first authorize the company in writing to act as her dual agent, at least for this property, before the buyer may be shown the property. If the written buyer agency agreement had already authorized dual agency, then there would not have been any impediments to either showing the property or preparing and presenting an offer. The NCREC also has strict guidelines regarding the appointment of designated agents that the BIC must follow. If the BIC represents one of the parties as a designated dual agent, the BIC can appoint only a licensed non-provisional broker as the designated dual agent for the other party. The BIC cannot appoint a provisional broker as a designated dual agent if the BIC represents the other party. The BIC may, however, appoint a licensed non-provisional broker to represent one party, and appoint a licensed provisional broker to represent the other party, or the BIC could be designated opposite a non-provisional broker. NCREC rules impose another major restriction on the appointment of a designated dual agent. Namely, if an agent has received confidential information about one party to the transaction, that agent has an obligation to refuse an appointment as the designated dual agent of the other party to the transaction. After a broker has been appointed as a designated agent for one of the firm's clients, the designated agent exclusively represents the principal in the transaction. Therefore, if the agent learns any confidential information about the other principal in the transaction after being designated, the designated agent must disclose that information to the client that they exclusively represent. This is a major reason that firms should protect the transfer of information within the firm. An agent who illegally becomes a designated dual agent when already in possession of confidential information about the opposite principal in the transaction creates potential legal liability for the firm as well as becoming subject to possible disciplinary action by the NCREC. Further, the company may have legal exposure if the post-designation receipt of confidential information occurs in-house. Note that while a client's confidential information must be kept confidential, agents must always disclose any information required by law to be disclosed, such as material facts about the property. Some important points about dual and designated dual agency include the following. To become a dual agent, the same firm must have a client relationship with both the seller and the buyer. There cannot be designated dual agency unless dual agency exists first. The firm owes the same fiduciary duties to both parties, which has the effect of neutralizing the firm and its agents when acting as dual agents. But designated dual agents owe their fiduciary duties exclusively to the party they are designated to represent, even though the firm has an equal obligation to both parties. Designated dual agency is a form of dual agency that is optional, but it has the potential to result in both of the firm's clients receiving better representation. To practice dual or designated dual agency, the firm's policy must authorize it and both parties must give their written consent. There are practical issues for brokers to consider if their firms are to practice designated dual agency. A firm with a handful of brokers may find it difficult to appoint agents if they have been tainted by in-office discussions about the transaction or its parties. It could be argued that no broker, including the one who may have initially represented both the buyer and the seller, should remain in the transaction, but rather should recuse himself or herself from being a part of the transaction any longer. Another practical question has to do with compensation. Will a broker who has been acting as a dual agent want to give up part of his or her earnings when the dual agency becomes a designated dual agency? Finally, the clients themselves may not want to be involved in designated dual agency when they have established a confidential relationship with one broker. Which client is turned over to a new broker representative? Another issue to consider in the handling of dual agency relationships is whether the clients have hired a sole practitioner rather than a real estate firm with associated licensees. A sole practitioner, that is a one-person brokerage operation, can act as a dual agent but cannot act as a designated dual agent. Designated dual agency requires two individual brokers, each solely representing either the buyer or the seller. Note, real estate brokers in North Carolina cannot have a non-agency relationship with consumers. A non-agency relationship takes place when the licensee acts as a facilitator, transaction broker by assisting buyer and sellers without representing interests of either party. In those states where non-agency is practice, licensees must still disclose material facts. Agency relationships in real estate rentals. Another type of brokerage contract that creates an agency relationship is the property management agreement, which is entered into by a management firm, broker, and a property owner who wishes to hire someone to manage rental properties. As with all agency agreements involving a property owner, the property management agreement must be in writing from the formation of the relationship. The property manager, broker, becomes the agent and the property owner becomes the principal. The fiduciary agency relationship between the property manager, broker, and the property owner is the same as that between the broker and the property seller or buyer. Any licensed employees of the property manager, broker become subagents of the property owner. Prospective tenants are customers of the property manager, who owes certain duties to the tenants imposed by North Carolina real estate law, fair housing laws, and landlord-tenant laws. A property manager of residential property usually will represent only the property owner and will not seek to represent the tenant as well, which would cause the agent to become a dual agent. However, commercial tenants may or may not be represented. Whenever an agent seeks to establish an agency relationship with a commercial tenant, thereby making the tenant a client, the agreement for brokerage services between the broker and the tenant shall be express, and shall be reduced to writing not later than the time any party makes an offer to rent or lease property. Watch the video to learn more about agency relationships. Exclusive buyer agency brokerages were the most common form of brokerage entity before the Edina lawsuit. False. Dual agency is a lawful and acceptable practice in North Carolina, provided both parties understand and consent in writing to the practice. True. Learning objective. Describe agency disclosure requirements in North Carolina, how, when, and to whom proper agency disclosures must be made. In particular, explain the proper handling of dual agency disclosure. Agency disclosure in North Carolina. To resolve some of the potential confusion surrounding agency relationships, North Carolina requires that real estate agents disclose their agency status to both buyers and sellers in every real estate sales transaction. No later than first substantial contact with a buyer or seller, an agent must provide the buyer or seller with a copy of the mandatory NCREC published form titled Working with Real Estate Agents. You can view the form here. Merely providing the form is not sufficient. Brokers must review it with consumers. The Commission also provides a cue and a brochure about the form on its website. The Working with Real Estate Agents form is not required in lease transactions. In every real estate sales transaction, the broker must review available agency options to any prospective buyer or seller no later than first substantial contact. First substantial contact occurs when conversation between a broker and a consumer shifts from facts about the property to possible confidential information about the consumer's needs, wishes, and abilities, or when the consumer or broker begins to act as if there is a fiduciary relationship. Confidential information is information that would harm someone's negotiating position, including motivation, ability, and price. Let's look at a few examples of first substantial contact. Karen was holding an open house at her listing. While at the open house, Stephen stopped by to view the home. After taking a look around, Stephen began to tell Karen that he loved the house and was moving to the area for work. His first substantial contact occurred. Yes, Stephen began to tell her about his motivation for moving. Karen should stop Stephen immediately to review the Q and on WWREA brochure and ask him to sign the WWREA disclosure form. Tarek was on floor duty for his firm and received a call from a buyer interested in a property and had a few questions about the floor plan. After explaining the locations of the rooms, the buyer said thank you and hung up. His first substantial contact occurred. No, Tarek only gave house details and the buyer did not offer any information related to price, ability, or motivation. Bella is moving to NC from California. She sent a Facebook message to Hudson, a local real estate agent, and began to ask questions about a home he has listed in regards to what the seller is willing to accept. His first substantial contact occurred. Yes, the moment Bella inquired about what the seller would do, Hudson should have sent a message back to her to discuss the WWREA disclosure form in Q and a brochure. After going over the information, Hudson has no more than 3 days to provide a copy of the form. The broker must review the form with the buyer or seller and make a determination if the broker will act as the agent of the seller or the agent of the buyer. An agency relationship cannot be formed without this review. The nature and obligations of an agency relationship must be clearly explained to the consumer so that the consumer understands that an agent owes all client-level fiduciary duties only to the client, principal. The purpose of the agency disclosure form is informed consent by the consumer as to the best agency relationship for them. A broker should always make agency disclosure prior to showing property to a buyer-consumer. First substantial contact with a prospective buyer occurs no later than the time information is gathered to use in the selection of properties for viewing. The Working with Real Estate Agents form contains information on the various agency relationships available, such as seller's agent, dual agent, buyer's agent, and seller's agent working with a buyer. If the first substantial contact does not occur face-to-face, then the form must be mailed, faxed, or emailed to the prospective buyer or seller as soon as possible, but in no event later than 3 calendar days from the date of first substantial contact. Then, the broker must review the contents of the form with the prospective seller or buyer at the earliest opportunity thereafter. The form is not designed to replace the review and explanation of agency by the broker, but rather to facilitate this explanation. The broker must keep a copy of the signed form on file for 3 years. It should be made clear to consumers that this disclosure does not create an agency relationship between the broker and consumers. It is not a contract. The purpose of the form is to educate consumers about choices that they can make in regard to their relationships with North Carolina brokers. Rule A-104 also requires a seller's agent or subagent working with a prospective buyer to disclose, in writing at first substantial contact, the agency status of representing the seller. If first substantial contact occurs other than a face-to-face meeting where it is not practical to provide written disclosure, the broker shall immediately disclose by similar means whom he or she represents, and shall immediately, but in no event later than 3 calendar days from the first substantial contact, mail or otherwise transmit a copy of the written disclosure to the buyer. Note that this written disclosure of seller agency or subagency to the prospective buyer is reflected in the form. There is a special rule regarding agency disclosure in auction sales. Rule A-104 states that providing the form to buyers does not apply to licensees representing sellers in auction sales transactions. However, A-104 still applies. A written listing agreement between the seller and a broker is required from the outset of the relationship. Be aware that Rule A-104 does apply in its entirety to licensees representing buyers in auction sales. In other words, licensees representing buyers must have reviewed the working with real estate agents form with their buyer client, and have a written buyer agency agreement with their client prior to submitting any bids. While licensees representing buyers in auction sales need not disclose their buyer agency status in writing to the seller at the time they bid, they must confirm it in writing ... no later than the time of execution of a written agreement memorializing the buyer's contract to purchase. As per Rule A-104, working with real estate agents Q and a brochure. The WWREAQ and a brochure is shown here. Note, this brochure is for informational purposes only and does not constitute a contract for service. Example: a broker is holding an open house for a seller client of his firm. Many prospective buyers tour the listed property during the afternoon. Does the broker have to provide and review the working with real estate agents form with the prospective buyers? If so, at what point must the agency disclosure occur? Most prospective buyers will tour the open house without requesting or disclosing any confidential information. If all conversation between the consumer and the broker is strictly facts about the property, first substantial contact has not been reached and agency disclosure is not mandated. However, if the consumer begins asking more specific or personal questions, the form must be reviewed and the broker and prospective buyer must determine and agree in what capacity the broker will work with the buyer, whether as a seller's subagent or as a dual agent. If the buyer-consumer is not ready or willing to enter into an agency relationship with the broker and his firm, the broker would indicate unrepresented buyer on the form. If the buyer-consumer is ready and willing to enter some form of buyer agency with the broker and his firm, they must determine whether the buyer and dual agency agreement will be written or oral, and whether designated agency is authorized. Full disclosure of agency options to consumers as soon as possible should always be the preferred action. Oral buyer agency is an agency option a firm may use when the consumer is unwilling to commit to a written buyer agency relationship. A real estate broker may enter into an oral buyer agency agreement at first substantial contact with a prospective buyer. A broker who works with and represents a buyer initially under an oral agreement must do so in a non-exclusive capacity. All oral buyer agency agreements must be non-exclusive. Any buyer agency agreement that seeks to bind the buyer to the broker or firm for a particular time period, or that prohibits the buyer from working with other brokers or firms, must be in writing from the start. Under the oral buyer agency agreement, a buyer is free to enter into similar agreements with other firms and brokers. An oral agreement is considered to be of indefinite duration and can be terminated at the will of either party at any time. Example: a broker is contacted by a prospective buyer to look at properties for sale. During the initial interview, the broker merely hands the form to the buyer without any explanation or review and tells the buyer he will represent the buyer as her agent during this transaction. Has a buyer agency been formed? The answer is no. The form must be reviewed and the broker and prospective buyer must mutually agree in what capacity the broker will work with the buyer, whether as a seller's subagent or as a buyer's agent, and if the latter, whether under an oral or written buyer agency agreement. Rule A 104 also states, a broker shall not continue to represent a buyer or tenant without a written agreement when such agreement is required by this rule. A broker must enter into a written buyer agency agreement no later than the time the first offer to purchase is presented. A buyer's agent working under oral agency cannot actually present the offer to the seller's agent unless the buyer, client first has signed a written buyer agency agreement. Although a broker may enter into an oral buyer agency agreement at first substantial contact, the rule does not prohibit the broker from getting an agency agreement in writing at first substantial contact. The written agency agreement does not have to be exclusive, but the broker should attempt to get the agency agreement in writing as soon as possible. Example: broker has given the prospective buyer the form at first substantial contact, has reviewed it with the buyer, and has entered into an oral buyer agency agreement with the buyer. The buyer finds a home and wants to make an offer. After the offer has been prepared and before presentation to the seller or seller's agent, broker attempts to get the buyer agency agreement in writing and signed by the buyer as required by Rule A 104. The buyer refuses to sign the buyer agency agreement. At this time, broker can no longer represent the buyer, but can present the offer acting as the seller's subagent with the buyer's and seller's permission. Of course, as the seller's subagent, broker must share information about the buyer, customer with the seller, client, and is no longer required to keep information about the buyer confidential. In the previous example, the broker must follow very specific conditions in order to present the offer as a seller's agent or subagent. The broker must clearly explain to the buyer that the broker will now represent the seller and will have a duty to the now seller, client, to convey any information, confidential or not, about the now buyer, customer that the broker learned during their relationship as buyer agent under the previous oral agreement. The broker must officially terminate the oral buyer agency agreement in writing, which should include the former buyer, client's consent to do so, and an understanding that confidential information must be revealed. The broker must have the consent from the listing firm to act as a seller's subagent, and must provide written disclosure of his seller subagency status to the buyer. Note: prior to switching to seller subagency, the oral buyer agent should consider entering into a written buyer agency agreement limited solely to that property, which few reasonable buyers should refuse. Because a broker may work with a buyer under an oral buyer agency agreement, the rule of necessity also allows an agent to enter into an oral dual agency agreement that must also be put in writing no later than the time an offer is presented. In order to work under oral dual agency, the dual agency arrangement must have been discussed, and the prospective buyer must orally agree for the agent to be a dual agent at the time the oral buyer agency is established. The same applies to oral designated dual agency. The following may be used as a 5-point checklist to properly follow disclosure rules. The agency disclosure form must be given to prospective sellers and buyers no later than first substantial contact in all real estate sales transactions. A broker must review the form and a determination of agency status must take place. The buyer-seller can acknowledge receipt by signing the form. Listing agreements are required to be in writing from the start of the agency relationship. The rule allows for an agent to act as a buyer's agent, a dual agent, or a designated dual agent under an oral agreement, until such time as the agreements must be put in writing, which is not later than the time the first offer is going to be presented. Any buyer agency agreement that sets forth agency exclusivity or a definite period of time must be in writing from the start of the agency relationship. Dual agency practice questions. Final exam and licensing exam questions on the subject of dual agency can be very challenging. Consider the following 2 questions. A broker properly reviewed real estate agency relationships to a prospective buyer using the Working with Real Estate Agents form. The buyer chose to enter into a written buyer-agency agreement with the broker without authorizing dual agency. After the broker showed the prospective buyer several properties listed by other companies, the buyer asked to see one of broker's listings. Given these circumstances, what kind of approval or authority to act as a dual agent must the broker obtain in order to proceed with the transaction? Oral approval for dual agency from both the buyer and the seller before showing the property. Written authority to act as a dual agent from both the seller and the buyer before showing the property. Written authority from the buyer for the agent to act as a dual agent and oral approval of dual agency from the seller before helping the buyer write an offer on the property. Written authority to act as a dual agent from both the seller and the buyer no later than the time the agent presents an offer from the buyer to the seller. A broker reviews the working with real estate agents form with prospective buyer. The buyer is reluctant to enter into a written buyer-agency agreement with the broker's firm, so the broker and buyer agree that the broker's firm will represent the buyer for the time being under an oral buyer-agency agreement. Dual agency is not mentioned. After the broker shows the buyer several properties listed with the broker's competitors, the buyer expresses a particular interest in seeing a properly listed with the broker's firm. The broker's firm had previously executed a written listing agreement with the seller, but that agreement did not specifically authorize the firm to act as a dual agent when selling the owner's property. At this point, can the broker proceed to show the buyer the listed property in question without a written dual agency agreement from the buyer and the seller? Yes, but only if the broker first obtains oral permission of both the buyer and seller to represent them as a dual agent and obtains a written dual agency agreement with both before any offer is presented. Yes, because a written dual agency agreement with the buyer and seller is not required for in-house sales. No, because a written dual agency agreement with both buyer and seller is required before any showing of a firm's listing to a buyer client of the firm. No, because having not authorized dual agency in the written listing agreement, the seller may not now orally authorize dual agency. Dual agency answers. The answer is B. In this situation, because both the listing agreement and the buyer agency agreement already are in writing, oral consent to dual agency will not be sufficient. The buyer client must first authorize the company in writing to act as a dual agent, at least for this property, before the buyer may be shown the property. If the written buyer-agency agreement had already authorized dual agency, then there would not have been any impediments to either showing the property or preparing and presenting an offer. The answer is A. If the oral buyer-agency agreement does not already authorize dual agency, the broker first must explain dual agency to the buyer and obtain the buyer's consent. Then, before the broker may show the property, the broker first must contact its other principal, the seller, explain dual agency, and obtain the seller's consent at least orally. If the seller refuses to consent, then the property may not be shown to the buyer client. Note, even though the listing agreement already is in writing and does not authorize dual agency, the seller's oral consent to dual agency as to that buyer is sufficient only because the buyer-agency agreement is still oral. If after viewing the property, the buyer wishes to make an offer, the buyer-agency agreement first must be reduced to writing and must contain authorization for dual and/or designated agency before any offer is presented. Further, the seller's written consent to dual designated agency, at least for this buyer, must be obtained before the offer may be presented. This may be done as an amendment to the listing agreement or as an addendum to the listing agreement, but it must be in writing before the offer is presented. Brokers are strongly advised to first obtain all necessary agency authorizations in writing before they prepare an offer. Otherwise, they may waste time preparing an offer they cannot present. The purpose of the working with real estate agents disclosure is to create an agency relationship between brokers and consumers. False. Oral buyer agency is a lawful alternative to use when a consumer is unwilling to commit to a written buyer agency agreement. True. Learning objective. Describe the scope of responsibility of the broker in charge to licensees within the firm, particularly from the perspective of the IRS. Nature of the brokerage business. Even if affiliated with a national franchise or marketing organization, a real estate broker is an independent businessperson who sets the policies of the broker's office. A broker in charge may engage employees and other brokers, determine their compensation, and direct their activities. A broker is free to accept or reject agency relationships with principals. This is an important characteristic of the brokerage business. A broker has the right to reject agency contracts that, in the broker's judgment, violate the ethics or high standards of the office. However, once a brokerage relationship has been established, the broker represents the principal and owes that person the duty to exercise care, skill, and integrity in carrying out instructions. Broker in charge, licensed associate relationship. Although brokerage firms vary widely in size, few brokers today perform their agency duties without the assistance of other brokers. Consequently, much of the business's success hinges on the broker in charge, licensed associate relationship. A provisional broker is licensed to perform real estate activities on behalf of a licensed real estate brokerage firm. The broker in charge is fully responsible for the actions performed in the course of the real estate business by all persons affiliated with the brokerage firm. In turn, all of a provisional broker's activities must be performed in the name of the broker in charge. A non-provisional broker associate has more autonomy in brokerage activities, but generally will still operate under the supervision of a broker in charge. The provisional broker can carry out only those responsibilities assigned by the broker in charge under whom the provisional broker is actively licensed, and can receive compensation only from that broker in charge. A broker's license must be on active status when brokerage activity is performed. Affiliated full brokers must be compensation by the supervising broker in charge. Further, brokers must stop all brokerage activity when their licenses expire or become inactive. In other words, as agents of the broker, provisional brokers have no authority on their own to make contracts with or receive compensation directly from any other party, whether the principal, another broker, a buyer, or a seller. Independent contractor versus employee. The employment agreement between a broker in charge and a licensed associate preferably should be in writing and should define the obligations and responsibilities each has in the relationship. The broker in charge is responsible for supervising all provisional brokers in any brokerage activity, and may be answerable to the Real Estate Commission for the conduct of those provisional brokers. A broker in charge has fewer supervisory responsibilities for the associated non-provisional brokers, who are held more accountable for their own acts, thereby reducing the broker in charge's exposure to disciplinary action by the Real Estate Commission for the conduct of the associated non-provisional brokers. The real estate company remains civilly liable for the acts of all of its associated brokers, whether provisional or non-provisional. Associated brokers with an active license may be paid for tax purposes either as a Form W-2 employee or as a Form 1099 independent contractor. This distinction is relevant primarily for tax purposes and is determined by tests set forth by the IRS as to the degree of control exercised by the employer principal over its employees, agents. The real estate broker may reimburse marketing expenses or require an employee to follow rules such as those governing working hours, office routine, assignment of sales quotas, and adherence to dress codes. A broker's relationship with a broker associate who is an independent contractor is different. As the name implies, an independent contractor operates more independently than an employee, and a broker may not exercise the same degree of control over an independent salesperson's activities. Although the broker may control what the independent contractor does, the broker cannot dictate how to do it. The broker cannot require the independent contractor to keep specific office hours or attend sales meetings. The primary distinction for the employer principal is that the employer is liable for withholding and paying Social Security and income taxes to the IRS for persons who are paid as Form W-2 employees, whereas Form 1099 independent contractors are responsible for reporting their income and paying estimated taxes with no contribution from the employer principal. An employer may pay certain benefits on behalf of its employees, but not its independent contractors, and generally will be required to pay unemployment compensation tax on the wages of its employees, but not its independent contractors. Regardless of whether associated brokers are paid as employees or independent contractors, the real estate company has the right to determine company policy and dictate certain procedures or rules governing how its associated brokers will conduct their brokerage business, as they are engaging in brokerage as agents of the company which remains liable for its broker's conduct. In practice, the IRS often investigates the independent contractor versus employee situation in real estate offices. Under the qualified real estate agent category in the Internal Revenue Code, 3 requirements can establish independent contractor status. The individual must have a current real estate license. The individual must have a written contract with the broker containing the following clause. The salesperson will not be treated as an employee with respect to the services performed by such salesperson as a real estate agent for federal tax purposes. 90% or more of the individual's income as a broker must be based on sales production and not on the number of hours worked. The broker should have a standardized agreement drawn up or reviewed by a lawyer to ensure its compliance with these federal dictates. The broker should also be aware that written agreements mean little to an IRS auditor if the actions of the parties are contrary to the document's provisions. Properly licensed brokers can be paid as employees or as independent contracts. True, employers are liable for withholding payment of Social Security and income taxes for persons who are paid as Form W-2 employees. True. Key point review. An agent is hired by principals to act on their behalf. Agency is the fiduciary relationship in which the agent is held in a position of special trust and confidence by the principal. A client is the principal. A customer is the non-represented party for whom some level of service is provided and who is entitled to fairness, honesty, and disclosure of material facts. Real estate agency relationships are governed by common law, which is established by tradition and court decisions, and statutory law enacted by the General Assembly, and rules promulgated by regulatory agencies such as the North Carolina Real Estate Commission. A universal agent is empowered to do anything the principal could do personally. A general agent represents the principal in a broad range of matters. A special agent represents the principal in one specific act or business transaction only, under detailed instruction. Real estate brokers are typically special agents. Creation of agency may be accomplished by a written listing or property management agreement with a property owner, a written or oral buyer agency agreement, a tenant representation agreement, or a dual agency agreement. Agency relationships encompass the following. Express agency is based on a formal agreement between the parties. Implied agency results from the behavior of the parties. The compensation source does not determine agency because the agent may be compensated by someone other than agent's client. An agency can exist even if no compensation is involved. Gratuitous agency. Termination of agency may be accomplished by the completion, performance, or fulfillment of purpose of agency. Destruction or condemnation of the property. Expiration of the terms of the agency. Mutual agreement of all parties to the contract. Breach by one of the parties, who may be liable for damages, and operation of law, as in the bankruptcy of the principal. A single agency is one in which an agent, firm represents only one party in a transaction. A buyer's broker represents a buyer as an agent to find property that meets the buyer's specifications, as set out in the buyer agency agreement. A subagent is the agent of an agent. A dual agency is one in which an agent, firm represents two principals in the same transaction. A designated agent is authorized by the broker to act as the exclusive agent of a specific principal in a dual agency situation. Non-agency relationships where the broker acts as a facilitator or transaction broker is not permitted in North Carolina. Disclosure by real estate brokers of agency relationship is required in every state. NCREC's Working with Real Estate Agents form does not create agency. Only proof of disclosure of agency relationships, and a broker must review all agency options with consumer no later than first substantial contact. Request signature of consumer. An agent has a fiduciary relationship of trust and confidence with the principal. Transactions should be arm's length with no self-dealing by the agents. The 6 common law fiduciary duties can be remembered as OLDCAR, which is an acronym for the following. Obedience. An agent must act in good faith at all times, with obedience toward the principal's instructions that are legal and ethical. Loyalty. An agent must place the principal's interests above those of all others, including the agent's own interests. Disclosure. An agent is duty-bound to inform the principal of any information concerning the transaction that might reasonably influence the principal's decision, particularly those mandated by state law. Confidentiality. An agent must keep the principal's price, terms, and motivation confidential at all times. Accounting. An agent must be able to report the status of all funds received from or on behalf of the principal. Reasonable skill and care. An agent must exercise a reasonable degree of care. Duty to third parties. Comply with license law and NCREC's rules and to be fair and honest, including disclosure of material facts, which include facts about the property itself, facts relating directly to the property, fact relating directly to ability of parties to complete the transaction, facts of special importance to the party. Statements to clients and customers should be clearly identified as opinion or fact. Note the following distinctions. Huffing is legal exaggeration of a property's benefits. Fraud is the intentional or willful misrepresentation or omission of a material fact to harm or take advantage of another person. Negligent misrepresentation occurs when a broker should have known that a statement about a material fact was false. Willful misrepresentation occurs when the broker knowingly makes a false statement. Negligent omission occurs when a broker did not disclose a material fact that the broker should have known. Willful omission occurs when the broker deliberately withholds relevant information. Stigmatized properties are seen as undesirable due to events, not the condition of the property. Death or serious illness of an owner or occupant of a property or the presence of a sexual offender in the area does not constitute a material fact that must be disclosed by brokers in North Carolina. Brokers have a duty to discover and disclose material facts to consumers, regardless of the party they represent. A broker-employer is liable for the actions of the provisional broker within the scope of the employment agreement. A real estate broker who is an independent contractor usually receives a commission with no withholding for Social Security, income tax, and other purposes, has the freedom to set hours and accomplish goals, does not relieve the broker of liability for related work activities of the broker, and must comply with IRS requirements for a qualified real estate agent. A broker who is an employee may receive salary in lieu of or in addition to commission, may receive benefits such as health insurance, profit sharing, and workers' compensation, has a broker who is required to withhold Social Security, income taxes, and other applicable federal and state taxes from earnings of the broker, has a broker in charge who sets hours, duties, and other specifics of day-to-day work, and has a broker in charge who has liability for related work activities of the broker.